Abusia Yamakwaba Shonkoso Eba POG Media. Ene Yadamako highway so highway there. And some baby was so Yanso Yaje Penny say Abami Abida Fono, and dear Elko. Ene dear Ebana Dana Elko so Ewo highway so. A year Speaker of Parliament Alban Bagbin. Ono ena watoto eja ama nanado dankwa Akuffo Addo enye asem ketu akra na parliament o de ewayi butubutu a Bagbin no ono de ose nanado dankwa Akuffo Addo no se nanado dankwa Akuffo Addo ono no se on sign Třumǔ gay bill na anti-gay bill ne dia se pass ono nso no ne reshuffle na oye no ministers na ono nso de ba no omo nso endorse no parliament ho ne endorse ni Čhǎ0s see ade akoye entokwa between Alban Bagbin and Nana Addo Akuffo Addo enye asem ketu akra na ura parliament onso a chese parliament no obia enso eta speaker of parliament achi de Nana Addo Akuffo Addo no oye no enye ade a esefata Ghana for ebu efu Nana Addo Akuffo Addo yi ankasa na Alban Bagbin so ono no ote ase ne de Ghana Třumǔ ne de yenje entumu ene enje entumu echna into kwa parliament a de ekoso ewo parliament ono na anti-gay bill no Ghana for the omano atutuma ensem bebre na afri ho aba na Nana Addo Akuffo Addo no waye na adwen se pass obesign de on sign ne ensign cha na Alban Bagbin so watutu eja amano wakeke bia kire Nana Addo Akuffo Addo a enye asam ketu akra intino yebepe se yebemi abidwafo no bemi akona yakwa tie ensema ekoso na answer na bekono o ensem kan bia fa share your comment section like na share ma afofro so ensa entumi enkabi medamase
from the suspension. I'm told the suspension was to be for 1 hour. It's taking longer than that. I understand why, because there were a few discussions behind the scene, the usual channels of communication. But I think it's right and proper for me to thank all of you for holding on the fort in my absence. I had to lead a delegation to attend a conference on behalf of the Parliament of Ghana, and in fact Ghana, a very, very important conference, a global council for political renewal. A global council for political renewal. I had key members, including the former majority leader, Honorable Chairman Sabunsu, to ably support me at the conference. I just arrived this afternoon, and since today is the last day of the sitting of the House for this meeting, I rushed to come to support you and well. I've been giving a lot of brief by leadership and my able second deputy speaker, who I'm extremely grateful to for holding on the fort. I know the first deputy speaker was very, very busy. It forms part of a series of actions that undermine the legislative. As you may recall, I addressed this House on the 22nd of December 2023 in a formal statement. The purpose of that statement was to draw your attention to the President's refusal to assent to 4 critical bills passed by this House. 3 private members' bills and 1 public bill. During that address, I underscored the troubling nature of the President's justification for his actions, or rather, the lack thereof, particularly highlighting that his failure to assent on grounds of alleged unconstitutionality paradoxically stood in violation of the very constitution he invoked. Despite the gravity of this matter, it is disheartening to note that there has been no progress in rectifying the situation concerning those significant pieces of legislation. They remain in a state of limbo, unreturned to Parliament, detained by him, and unacted upon, following the President's communication, which lacked substantial legal justification. This ongoing scenario poses a grave threat to our legislative authority and, by extension, the democratic principles we try to uphold. The implications of such executive actions extend far beyond the immediate legislative items at hand. They erode the foundational checks and balances that our forebears painstakingly established to ensure a vibrant and functioning democracy. When important legislative work, the product of rigorous debate and consensus building within this House, is disregarded without just cause, it not only disrespects the legislative branch, but also disenfranchises the citizens that we are sworn to serve. This blatant disregard for legislative processes and constitutional mandates risks setting a perilous precedent that could weaken the very fabric of our governance structure. Honorable members, on 19th March 2024, my attention was drawn to a letter issued by the Executive Secretary to the President, Nana Asante Bediotuo, addressed to the Clerk to Parliament, which letter is clearly, in my opinion, contemptuous of Parliament. The letter outlined that the Clerk ought to, and I quote, cease and desist, unquote, from attempting to transmit the Human Sexual Rights and Family Values Bill 2024 to the President for necessary action in accordance with the provisions of our Constitution. In the said letter, the Executive Secretary indicated that the Office of the President was aware of 2 pending applications for an order of interlocutory injunction seeking to restrain the Clerk from transmitting the bill to the President. It further indicated that the Honorable Attorney General had on 18th March 2024 informed the President that he had received the 2 applications and had advised the President not to take any step in relation to the bill until matters raised by the suit are determined by the Supreme Court. As a result, the President, via the Executive Secretary, conveyed conveyed to the clerk that it was unable to accept transmission of the bill. Honorable members, my attention has also been drawn to the 18th March 2024 letter from the Honorable Attorney General being referred to by the Executive Secretary to the President, Nana Asante Bidiochu above. In the said letter, that is the letter from the Attorney General, I note that the Attorney General used the phrase, and I quote, "I will respectfully advise that a decision to assent to the bill be made after the determination of the application for interlocutory injunction," unquote, and not an advice to the President not to receive the bill from Parliament. It is therefore interesting that in view of this clear and unambiguous advice from the Attorney General, which I disagree with, to the President has rather chosen to accept the bill. In the face of these developments, it is important for us as a House to reflect upon the manner in which these events have unfolded. On the 20th of February 2024, this August House took a decisive step in passing the bill, a move that was a culmination of rigorous debate, thoughtful deliberations, and the collective will of the representatives of the people. Following this, the bill underwent the customary process of cross-checking, which is an important procedure designed to ensure that all amendments and changes proposed during the legislative process were accurately incorporated. After the successful processes were done with, the Clerk to Parliament, fulfilling his duties as the procedural intermediary between the legislative and executive branches, and dared to send the bill to the President in accordance with Section 5 of the Interpretation Act 2009, Act 792. This action, steeped in established parliamentary practice and procedure, signifies the final step in the legislative process, enabling the President to review and, if assent to the bill, thereby enacting it into law in accordance with Article 1067 of the Constitution. The refusal to accept the bill for transmission did not occur in isolation, but persisted. Multiple attempts, with the third attempt to transmit the bill forming the basis of the letter I have previously alluded to. So 3 occasions to serve the bill. In fact, the Constitution used the word present the bill to the President, failed. Notably, the President's refusal to accept the transmission of the bill has not been formally communicated to this House through the established channels of official correspondence from the President to this House. The absence of an official communication to the House regarding the President's refusal is troubling. Yet, it does not diminish the gravity of the situation, nor our responsibility to address it. No communication from the President to the House is through the Speaker. Nothing like that has been done. The contents of the letter, albeit not formally presented to us, have come to our attention, compelling us to confront the issues it raises. It is a matter of great concern that the executive branch has chosen to disregard the established constitutional structures that constructive dialogue and collaboration between the branches of government. In light of these circumstances, it is incumbent on this House to stand united in its response to this affront to the legislative authority vested in Parliament by the Constitution and the people we serve. We must articulate a collective voice that unequivocally condemns the disregard for our constitutional structures and reaffirms our commitment to uphold this situation calls for a principled stance, emphasizing the importance of adherence to the procedures and norms that govern our democratic institutions. Honorable members, I want to make some comments on the legal framework for action to be taken after a bill has been passed. This is important for the information of all, including the people we represent. And I quote, where a bill passed by Parliament is presented to the President for assent, he shall signify within 7 days after the presentation to the Speaker that he assents to the bill or that he refuses to assent to the bill, unless the bill has been referred by the President to the Council of State under of this Constitution. Section 5 of the Interpretation Act 2009, Act 792, provides 2. As soon as a bill is passed by Parliament, the text of the bill as passed shall be sent by the Clerk of Parliament to the government printer, who shall print 4 copies of the bill on vellum paper or on paper of enduring quality and send the copies to the clerk. 4. On receiving the copies, the clerk shall carefully compare them with the text of the bill as passed, and if the clerk finds the copies to be correct, shall sign on each copy a statement in the form set out in the first schedule, and shall send the copies so authenticated to the President for the assent. 5. Where the bill was passed in accordance with the relevant provisions of Article 108 of the Constitution, the clerk shall, before causing the copies to be presented to the President, submit them to the Speaker, who, if satisfied that the bill was passed in accordance with the Constitution, shall sign on each copy a certificate in the form set out in the first schedule. 6. After the assent clerk shall enter on the appropriate number of the Act, unquote. The combined effect of these provisions read together is that after a bill is passed by Parliament, it undergoes a meticulous process designed to ensure its conformity with the nation's legal and constitutional standards before it can become law. Initially, the passed bill is sent to the government printer, who is responsible for printing on high-quality, durable paper. Following this, the clerk to Parliament conducts a thorough verification of these printed copies against the original bill and the amendments to ensure the accuracy. Upon successful verification, the clerk authenticates each copy by signing a statement that certifies the correctness. In Article 108 matters, an additional step is introduced. The authenticated copies are presented to the Speaker of Parliament, who must certify that the bill was indeed passed in accordance with Article 108 by signing a certificate on each copy. Honourable members, it's important for me to add this, that this issue about fiscal impact analysis is always done, and the report is always presented to me. And I read through all the reports, and I refer them to a legal person for advice. It's when I am advised that they conform to the Article 108, and I'm convinced that that advice is right, that I recommend them for processing by the necessary authorities. Final and perhaps most critical phase of the process involves the presentation of the bill to the President for assent. Pursuant to Article 106(7) of the Constitution, the President has a 7-day period to either assent to the bill, signifying its enactment into law, or refuse to assent, which may involve referring the bill to the Council of State for further advice. Upon the President's assent, the Clerk of Parliament assigns an official Act number to the bill, formally making it a law. If the President has concerns about the bill presented, the President refers the bill with the concerns for further consideration of Parliament. When that is done by Parliament and it is represented to the President is by law bound to assent to the bill. That is what is in the Constitution. Ghana, the President has no power of veto. Honourable members, I now make comments on the injunction applications and their effect on the law-making process. Honourable members, this House has been duly served with 2 injunction applications in respect of the bill. The applications titled Richard Sky versus the Parliament of Ghana and the Attorney General, and the second, Dr. Amanda Odoi versus the Speaker of Parliament and the Attorney General. Honourable members, you will recall that on the 19th of July 2023, the Supreme Court considered and dismissed an application for interlocutory injunction that sought to injunct the proceedings of Parliament in respect of the bill. The court in that case, Dr. Amanda Odoi versus and the Attorney General, J1/13/2023, reasoned that the application failed to meet the threshold for the grant of interlocutory injunctions. The Executive Secretary to the President noted in his letter that, and I quote, "It is settled law that during the pendency of an interlocutory injunction application, the status quo ante ought to be preserved and no action be taken that will result in prejudicing the injunctive relief sought and undermining the authority of the court," unquote. Honorable members, an injunction is a judicial order that restrains a person from beginning or continuing an action that threatens or breaches the legal right of another, or that compels a person to carry out a certain act, such as correcting a wrongful state of affairs. In the context of our law, interlocutory injunctions serve as an important tool for maintaining the status quo pending the resolution of a legal dispute, ensuring that the parties involved do not engage in actions that could cause irreparable harm or fundamentally alter the situation before the court as an opportunity to decide the case. I won't want to go into the law on injunctions because these two cases are sub judice. But it's important I say a few things. The act of transmission of a bill to the President merely represents the procedural progression of a bill within the structured framework established by the Constitution. It does not, in and of itself, guarantee the bill's enactment into law, as the President is accorded the authority, as clearly outlined in the Constitution, to either assent to the bill or refuse it under Articles 1067 and 1068. And you can refer to the Council of State for advice or refer it back to the House for reconsideration. Additionally, in the event that a bill is assented to by the President and becomes law, the Constitution provides a mechanism for judicial review. Articles 2, Clause 1 and 130 empower the Supreme Court to scrutinize the constitutionality of an act of Parliament. Should the court find that the law is unconstitutional, it possesses the authority to invalidate the act. Given these considerations, it is evident that the transmission of a bill to the President for assent does not result in irreparable harm that will justify the granting of an injunction, much less the halting of parliamentary process on account of the application of an injunction. Generally, the Supreme Court has upheld the position of the law that the official acts by organs of the state and government departments are presumed to be regularly performed unless there is strong evidence in rebuttal. Arising out of this, it is imperative to note that The courts have been very reluctant acting and placing impediments on arms of government and constitutional bodies from performing their constitutionally mandated duties. This has always resisted attempts to unfairly and unsuccessfully place a clock on the work of this House through the use of injunction applications. In Welford Kweku versus the Attorney General, the Supreme Court, per Dr. Datiba JSC, noted that, and I quote, where the relief sought relates, as here, to a public law matter, particular care must be taken not to halt action presumptively for the public good, unless there are very cogent reasons to do so, and provided also that any subsequent notification of the impinged act or omission cannot restore the status quo. Given the reliefs that the plaintiff is seeking in the substantive suit in this case, it is clear that if he succeeds in securing the declarations he has claimed, the impugned provisions of the Local Government Act 1993, Act 462, will be declared void, and any actions made in pursuance of that nullified. Accordingly, no irreparable damage will have been caused the plaintiff during the period between the issue of the rent and the date of judgment, unquote. In Dr. Amanda Odoi versus the Speaker of Parliament and the Attorney General, the court refused to grant the injunction application because no prima facie case had been made to restrain the work of Parliament, and further, the applicant was unable to prove irreparable damage should the work of Parliament continue in respect of the bill. This same bill we are talking about. The court's cautious approach in dealing with injunction applications against parliamentary processes further underscores the importance of not hastily impeding the legislative functions of Parliament. The precedents, as I've just set out, show that courts have been slow to grant injunctions that will have to halt the work of Parliament, recognizing the profound implications such actions could have on the legislative autonomy and the balance of powers within the government. The judicial reticence is rooted in the recognition of the fundamental principles underpinning a democratic society, where each branch of government operates within its own sphere of influence, with specific duties and powers that are designed to complement each other, ensuring a robust system of checks and balances. The courts, in exercising their discretion in matters of injunctions against Parliament, demonstrate a careful consideration of these principles, opting to intervene only when absolutely necessary and when the legal threshold for such interventions are unequivocally met. Honourable members, it's time for reflective conclusion. Several critical points emerge that underscore the importance of adhering to constitutional and legal frameworks within our democratic governance. Firstly, the President's refusal to accept the transmission of the bill is, by all accounts, not supported by the constitutional and statutory provisions that guide our legislative process. The Constitution clearly delineates the steps to be followed once a bill has been passed by Parliament, mandating the transmission of the bill to the President for assent or rejection. Therefore, the refusal to even accept the bill for consideration falls outside the legal bounds established by our constitutional framework. It is incumbent upon the President to accept the bill and take the necessary action within the prescribed constitutional limits, whether that action is assent, refusal, or referral to the Council of State for advice or Parliament for reconsideration. It is instructive to note that the Executive has in the past proceeded with these actions, although there has been pending before the court injunction applications against the state. Secondly, there must be a steadfast rejection of any attempts to unduly fetter or hinder the work of Parliament. The Parliament of Ghana operates as a crucial part of our democracy, embodying the will and voice of the people. Parliament embodies the sovereign will and power of the people. Parliament embodies the might and majesty of the people. And as I keep on saying, the power of the people is stronger than the people in power. Any efforts to obstruct its work, Parliament's work, disrespects this fundamental institution and threatens the principles of governance by consent and representation. Thirdly, it is imperative to remain vigilant against certain dangerous precedents that could potentially undermine the foundation of our democracy. The rejection of a bill's transmission without constitutional basis introduces a precarious deviation from established democratic practices and norms. Such actions, if left unchallenged, may embolden future attempts to circumvent the legislative process, thereby weakening the integrity and efficacy of our democratic institutions. Lastly, in alignment with our constitutional mandates and the principles of good governance, it is essential for the President to adhere to the lawful course of action by accepting the transmission of the bill. Upon receipt, the President has the constitutionally provided options as to what to do. I don't want to repeat it here. As we move forward, it is the collective responsibility of all branches of government and indeed all citizens to uphold the Constitution and ensure that our democratic processes are not only preserved but strengthened. The current impasse presents an opportunity for reflection and reaffirmation of our commitment to the principle of democracy, rule of law, and the unequivocal respect for the legislative process that forms the bedrock of our nation's governance. Honorable members, the Parliament of Ghana will comply with the existing legal frameworks and reject the attempts by the Executive Secretary of the President through his contemptuous letter to instruct the Clerk to Parliament, an officer of Parliament who is recognizably under the Constitution. We shall not cease and desist. Be that as it may, honorable members, I also bring to your attention the receipt of a process from the courts titled Robson. Honorable member, I'm watching you. And I hear what you say. Be that as it may, honorable members, I also bring to your attention the receipt of a process from the courts titled Robson Nelson Eche K. Dafiamapo versus the Speaker of Parliament and the Attorney General. Suit number J1/12/2024, which process was served on the 19th, that is yesterday, March 2024, and an injunction motion on notice seeking to restrain the Speaker from proceeding with the vetting and approval of the names of the persons submitted by His Excellency the President until the provisions of the Constitution are satisfied. Honorable members, in the light of this process, the House is unable to continue to consider the nominations of His Excellency the President. To use the language of the Attorney General and Minister for Justice, quote, in the spirit of upholding the rule of law, unquote, until after the determination of the application for interlocutory injunction by the Supreme Court. Honorable members, this is the precedent that is being set by His Excellency the President for all Ghanaians to follow. So any matter that comes before Parliament, any Ghanaian can issue a writ and follow it with an application for injunction. And that is enough to injunct Parliament from proceeding with the consideration of the business in the House. Honorable members, I thank you all for your attention, and may God bless our homeland, Ghana.
ɛne ensema ɛkɔso ɛwɔ Parliament House a ɛnyɛ asɛm ketewa koraa. Speaker of Parliament Alban Bagbin ɔno ɔse sɛ paa sɛ ɔte ase deɛ ɔntwema na Addo dankwa Akuffo Addo ne ɛntwe ɛma ne kyena na Třumǔ no deɛ ɛnkɔso ɛwɔ Ghana ase. Yɛbɛde abadwafo ase sɛ ɔmogye pene kɔkɔtii saa audio yi na ansa na yɛbɛkɔ no ɔwɔ nsɛmka bi afa hyɛ your comment section like click on the notification bell so na ɛbɛyɛ any update bi a de bɛbrɛ mu biara no wo nsa bɛtumi aka bi aha ɛyɛ POG Media medam ase.